This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about dogs and why a dog is nothing more than a dog. And even if that dog lives at a house, he or she is not a part of the property. Lana Sloan appealed from summary judgment entered in favor of Farm Bureau Town and Country Insurance Company in Missouri while she sought medical payments for injuries she received from a less than obedient and loving dog. In Lana Sloan versus Farm Bureau, the Court of Appeals of Missouri on August 15, 2024, found that summary judgment established a dog was not a part of the premises, which was a requirement of the coverage of the policy from which Sloan sought benefits. Joseph Webb owned residential property insured by Farm Bureau. Webb leased the insured premises to a person named Jesse Clark, who owned a dog. Webb neither owned nor cared for the dog. Clark's dog bit Sloan while she was walking on a public roadway adjacent to, but not on the insured premises. Sloan made a claim under the medical payments provision of the Farm Bureau policy on which Joseph Webb was the only named insured. The Farm Bureau policy provided coverage for medical payments to non-insureds when such persons sustained bodily injury on an insured premises with the permission of any insured or elsewhere if the bodily injury arose out of a condition on the insured premises, was caused by the activities of the insured or the insured's relatives if the insured is a person, and was caused by a resident's employee in the course of employment by the insured or his or her relatives, or is caused by an animal other than livestock owned by or in the care of the insured or the insured's relatives. Farm Bureau denied Sloan's claim. She sued, alleging that Farm Bureau was liable under Missouri Statute Section 375.420 for its vexatious refusal to pay her. The only dispute on summary judgment was the applicability of Section 2A, that is, whether Sloan's injuries, which occurred off the insured premises, arose out of a condition of an insured premises. The Circuit Court found that the dog was not a condition of the insured premises. The loss was not covered under the policy, and Sloan could not prove the dog was a condition of the insured's premises with all of the discovery she tried. The statutes allow penalties to be assessed against an insurer when it refuses to make payment upon demand in accordance with the policy, vexatiously, willfully, or without reasonable cause, because loss is modified by the prepositional phrase, quote, under a policy, close quote, in Section 375.420. Only those losses insured or covered by the policy satisfy the statute. Where an insurer had no duty to pay under the insurance policy, there cannot be a claim for vexatious refusal to pay. The interpretation of an insurance policy is a question of law, and when a term within an insurance policy is undefined, the court will apply the plain meaning, that is, the meaning that would be attached by an ordinary person of average understanding if purchasing insurance. Sloan contended her loss was covered by the policy because a dog kept on the insured premises is a condition of the insured premises from which an off-premises attack and injury could arise. To the court, it was apparent that a premises is common parlance, and in the policy itself contemplates the land and more or less permanently affixed structures contained thereon. It does not contemplate easily movable property, which may be located on the property at a given time or even on a regular or permanent basis. A dog, whether permanently kenneled or tethered on the property, is not a part of the premises. The non-coverage of the loss in this case was consistent with the principle that landlords generally are not liable for injuries to others caused by a tenant's dog. Ownership of real property does not make one an owner, possessor, or harborer of the domestic animals found on that property. There is a serious distinction between real property and domestic animals kept on that property. The Court of Appeals concluded that Sloan's injuries did not arise out of a condition of the insured premises. In my opinion, a dog is a living, breathing animal. It can live at a piece of real property just like its owner or tenant may live at the premises, but neither the owner, tenant, nor pets are part of that property. Since to succeed, Sloan needed to prove her injuries arose out of a condition of the insured premises. The judgment in favor of the insurer was affirmed because she couldn't. Dogs move. People move. If the dog's owner had accidentally injured her or intentionally injured her off premises, the same result would have applied. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,850 blog postings. You can also subscribe to these videos on rumble.com and youtube.com. They're free. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in more detailed information about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.